Patent freedom claims that the number of operating companies that faced assertion from non-practicing entities in 2010 was more than 2,600 companies. That's an increase from 500 companies in 2004. And a subsequent study by researchers at Boston's University School of Law says the costs to society and these large corporations are in excess of $500 billion. So how do corporations avoid feeding non-practicing entities when they're selling patents? Because patents are property that can be sold on. And the sellers are often corporations, and they want to restrict those patents that they sell from landing subsequently into the hands of non-practicing entities and then being aggressively asserted. Is this possible? Is it possible to control how patents are used after they've been sold? Can you restrict the buyer's use of a patent by contract? Well, yes, typically you could, and the restriction will carry with the patent when the patent is sold. You could restrict the buyer from reselling the patents by contract. The patent seller, the corporate seller, could retain a right of first refusal. Now, the problem here is that these types of contractual restrictions and license restrictions, of course, affect the value of the patents and the sellability. Who would buy patents with such restrictions on their use? It's hard to find a buyer prepared to make such a commitment. After all, you can do with a patent essentially is assert it against infringers. There is another approach, and that is the sublicense right that is retained by the patent seller, the corporate seller. Some large sellers will retain a license back when selling the patent with a right to sublicense under certain conditions. They retain the right to sublicense to an infringer if they believe the patents are being aggressively asserted by a non-practicing entity. So the sublicense is used to block aggressive assertion after the patents have been sold and maybe subsequently sold on. So when the original patent seller sees aggressive assertion of the patents or the patents used against its wishes, the license back with the sublicense can be used to nullify the dispute by providing a license to the accused infringer. Now, is this acceptable to buyers? And the answer is rarely. It's only acceptable where the buyer is going to be okay with the restrictions. If it's a defensive buyer, they have no intention of reselling the patents, they have no intention of running aggressive assertion programs with the patents. They're buying the patents so they can use them in a counterclaim in a defensive method if they're sued by one of their competitors. Now, this obviously, though, has a serious impact on the value. Patent sellers that are concerned that patents are not used in an aggressive assertion by an NPE or other buyers can retain sublicense rights that give the seller powers to rescue accused infringers. But the downside is it does restrict the sellability and the value of the patents that the corporation's trying to sell. The number of buyers that are prepared to acquire patents under these conditions is relatively few.